And now we should be live on. Okay. Welcome to Abolition April, presented by Abolitionist Sanctuary and Abolition Academy 101. I'm excited as your host. I am Reverend Dr. Nakia Smith Robert, the founder and executive director of Abolitionist Sanctuary. Our mission is to lead a faith based movement by training Black serving churches, civic organizations, and educational institutions how to organize against the moral crisis of mass incarceration and the criminalization of impoverished Black motherhood. I am joined here with guest, Professor Natasha Robinson, Esquire, as Court TV. Welcome.
Hello, how are you?
I'm well. How are you?
I'm good. Thank you so much for having me here.
Thank you for joining us. As you bringing you 30 days of abolition. And we're excited that Professor Natasha or Professor Robinson is starting us off with our first installment of Abolition Academy 101, which consists of 3 days from April 17th, April 18th, and April 19th, looking at arrest in the first class. That is today. And then, secondly, we'll look at a court case to look at the real life implications of the legal system, particularly for Black women and Black mothers. And then on the final day, we'll look at the trial aspect of the criminal system. And we are excited to begin. So I will read a bio. Natasha Robinson Esquire's pronouns are she, her, hers. She is the creator and curator LegalEaze, Please, an online platform and digital space founded in May 2020 that empowers the development of individual collective comprehension of criminal laws, cases, and these through decoding, deconstructing, and demystifying legal language. LegalEaze Please, a Black owned business created by a Black woman, provides relevant knowledge to legal information as well as equitable access for all users to understand and apply in their everyday lives. Professor Robinson was formerly an assistant teaching professor of criminal justice at Roosevelt University. She's taught courses relating to criminal justice and was a faculty member of the Government Law and Justice Department. Prior to coming to Roosevelt, Professor Robinson was a teacher in public schools teaching law courses, including criminal law and criminology, to high school students enrolled in the honors program. For 6 years, in addition to teaching, Professor Robinson also coached her high school students in preparation and civil mock trial exhibitions and competitions. Professor Robinson has been a licensed criminal defense attorney for more than 20 years, having served for 12 and a half years as an assistant defender of Cook County, specializing in the representation of clients charged with felony crimes. Professor is a regular guest legal analyst on Court TV, contributor to the Soul Town magazine. Professor of Arts in English from the University of Iowa, her Master's of Arts in English from Chicago State University, doctor from the University of Wisconsin Law School. All of her accomplishments, accolades, and awards, Grace, the most amazing of them all. Professor Robinson is the proud mother to Grace, Karen, and together they are each other's and love. For our remaining of our time, I present to you Professor Natasha Robinson, and I invite you to share this live right now to all of your friends and all of your network, and email them recordings or to come back same time, same place tomorrow and the day after. Thank you, Professor Robinson. Well,
Thank you, Dr. Nakia Robert. If I had a sound assistance or support, I was like, pew, 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 that kind of thing. I do not. Maybe I have one tomorrow, but not right now.
I
So
got it for you, but I'll leave it alone. But here's some clapping.
we'll save it. We'll gas them up for tomorrow. Thank you. Thank you. Thank you. Thank you. No, really, thank you. No. But thank you so much for having me here. And thank you to you. Yeah, all of this. All of this. Yes. 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 Thank you so much because you all, I'm talking to you now, the viewer, you have no idea what it is taken for both Dr. Nakia and myself to be here and to be here without any visible chaos. There's still chaos that is around, but we have tried to mitigate it because we believe this much in what it is that we are doing. So much so that we are coming to you when, as Black mothers, we are trying to get food ready, we're trying to give baths, we are trying to do homework. All of that has been done or will be done after this. So I just want you to know that you matter because we are here and we are present with you. So thank you again, Dr. Nakia, for allowing me to be here with you all for these next 3 evenings, tonight, tomorrow, and we're going to conclude on Wednesday. So without further ado, I'm going to go ahead and get started because I believe in people using their time wisely. So I'm going to go ahead and get started. If there are any questions that you have, you can write them down. You can jot them down. If you are watching on social media, you can put it into the comments. If I do not get to your questions tonight, I promise, I will give you information on how you can reach out to me and I can answer them, or I can wait until live time to be able to do it tomorrow or Wednesday. Also, as Dr. Nakia spoke earlier, I am a mama. And so at any point, I may have to turn back into a mama because as a single parent, sometimes our children, as much as we want them to be in a particular time frame and we've given all the instructions, all the directions, they still have a question or they still want to go ahead. And you know what? Because the type of relationship I have with my daughter, she's going to get that time. But hopefully she is situated. She is watching her programs, her cartoons. So we won't be here long. We hope to conclude within an hour so that you can go about your day, your afternoon, and your evenings. All right. So without further ado, today our presentation is called Abolition Academy 101, where we are going to be focusing on the arrest. Now, when we are talking about the criminal justice system in the United States, there are three components. The first you have is the law enforcement or the police component. Then the next component you have are the trials, the criminal case, where you choose to plead guilty or to plead not guilty, depending upon the evidence, depending upon your narrative of what happened, if you are the defendant, and then based upon what your attorney advises you. Now, if you are the victim complainant, then whether or not a trial occurs or a plea occurs depends upon the defendant. All right. And that's the second component. So the first component is the police slash law corrections enforcement. The second component is courts. And then the third component is corrections. Corrections is not only for those who are incarcerated or who are under the control of the state or the federal government, but those who are also on parole and probation. A lot of times when we have conversations about mass incarceration, we don't really include those who are on the outside, as it is referred to, but who do not have free movement because they still have to report, they still have to check in, they still have to follow different conditions that are regulated by the state or the federal government. So these are the three components that we're going to focus on. Now, before I get started, you heard Dr. Robert talk about the fact that I am the creator and curator of LegalEaze Please. It is a digital platform that is designed to decode, to demystify, and to deconstruct legal language. In short, we build you who are watching, we build you up by breaking it down. It being the interlocking systems of oppression, it being any barrier or any boundary that prevents legal knowledge, access, and comprehension. A lot of times we want to talk about the laws and we may have access to an attorney or to a legal professional. But if we do not have the comprehension to know what it is that they're talking about, if we do not have the unencumbered access to have these conversations, because think about it, when's the last time you had a conversation with a criminal defense attorney? Usually it is in a time of chaos. Same thing for those who wish to prosecute those who are going to be charged with a crime. Very rarely do you have conversations with legal professionals when there is no breaking or challenge of a law. And so LegalEaze Please is designed to engage in lifelong learning. The symbol that you see on the screen, it is pronounced Nia Oni. All right. It is an Ndinkra symbol, which when you look at these symbols, it signifies or denotes certain meanings. This translation is he who does not know, which means that while we have breath in our bodies, while we're able to continue to live in this realm and on this plane, we engage in the obligation, in the proactive learning of information, in this case, legal information. And so we believe at LegalEaze Please about the ethic of empowerment and liberation. We enter into these legal systems and we decode and demystify and deconstruct legal language, legal terms, legal cases, legal policies, so that you, as a layperson, are able to understand. We believe that should not have to be a legal professional in order to know about the law. You also do not have to go to law school in order to get a very introductory, comprehensive understanding of what the law is and what the law is not. Now, that is not to say we do not need lawyers. It is not to say do not go to law school or do not major in criminal justice. But what we are saying is that a lot of times these laws affect the everyday person who is not a legal professional. And we do not want finances, we do not want education, formal or informal. We do not want any barriers and boundaries to understanding what does different things mean. And in an ancestral way, I am here to decode laws and cases and statutes in the same way that for those who are of the African heritage, the African diaspora, in the same way our ancestors decoded the stars, in the same way that they decoded plants or nature. They were able to read different things with their hands. They were able to pass down from generations different ways of knowing and different ways of understanding. And that is why we are here, is to make sure that in the liberation, that you continue to liberate yourself and others through the reliance, through the relevance, and through the accessible legal education and comprehension of the law. That is what LegalEaze is for. Our partnership between Abolitionist Sanctuary and LegalEaze Please. LegalEaze is usually spelled LegalEase, I think. Okay. And so the reason why I changed it to ease is, as I said earlier, is that when we are learning information that has to do with criminal law, it is usually in a time of chaos. And I wanted to normalize us having those type of everyday conversations. So ease is really an acronym. It is really E period, A period, Z period, E period. The first E stands for education. The A stands for access or accessibility. The Z stands for zealous or zeal, which is the passion that we bring to making sure that you are taken care of and that you leave not having any type of questions or lack of comprehension. And we don't bring shame into this learning space. Think about your favorite teachers, your favorite subjects. You learned the most when you felt at home, when you felt comfortable. And so that is where the ease comes in, is that we want to make sure that you are comfortable. We know that for some of us, this can be traumatic. It can be triggering because we're engaging in some dense conversations about the realities that we live through. And so when you juxtapose, when you put that next to the ease, we are about building community and making sure that, as one of my mentors, Dr. Mama Ichihari Ture says, that we are a community that is strong enough to hold each other's truths. So we want to make sure that when we are partnering with Abolitionist Sanctuary, that we hold the truth of Black mothers and Black women who have been criminalized, who have been incarcerated for no other reason than because there is someone who believed that these women broke the law when in fact it was the law breaking them, to paraphrase Dr. Nakia Robert. All right, so that's what we are doing for these moments that we have together. And so we're about abolition, period. There are different ways in which we can engage in abolition. Abolition through the Abolitionist Sanctuary have the tenets of compassion, care, creativity, courage, and we do it in community. And so those are the tenets that LegalEaze Please is going to engage in being good stewards over as we have these conversations. Now, I want to put the framework of our webinar series in this way. Dr. Susan Williams Smith, who is the author, she's a phenomenal journalist and she has written several books. One of those books is called The Book of Jeremiah, which is dedicated to the life and memory of Jeremiah A. Wright Jr., his legacy, his preachment, different things like that. Well, in his book, well, I should say, in the book that is written about him that she wrote, he is talking about Dr. William Augustus Jones, who is the author of God in the Ghetto. And so, this quote that we are going to be reviewing is a quote in her book, but it is Dr. Wright talking about Dr. Jones. So, I want to set that up so that we understand the framework for this webinar series. Quote, Dr. Jones, this is Dr. Wright talking, Dr. Jones in his book, God in the Ghetto, argues quite accurately that one's theology, how I see God, determines one anthropology, how I see humans, and one's anthropology then determines one's sociology, how I order my society. I will say it again. Dr. Wright is talking about Dr. William Augustus Jones in Dr. Jones' book, God in the Ghetto. And Dr. Wright is summarizing Dr. Jones' main thesis, which is how we see God then determines how we see each other. And then how we see each other then determines how we order, how we hierarchy, if that's a verb, how we put into a hierarchy each other that we see. So, for example, if I see God as a male, white, long beard, capitalistic, cis hetero deity, then that is the framework for how I see others. So if you do not match my God, then you are at the lower part of my hierarchy, because now what you are doing is I don't treat you in the same way that I would treat someone else, because you do not match my God. I do not see divinity in you because my divinity is being archived, if you will, by way of someone who matches a capitalist, white, cis hetero person. Okay. So, oh, hold on 1 minute. Let me make sure I can show you the slides again. And hopefully you are able to see them. Just let me know. I'm just going to give it a couple seconds and you can tell me if you can see the slides.
Not yet. There is both a presentation function
Okay.
and
So I'm going to do then
have a
screen.
screen. Oh, try screen this time.
Okay. And then we will make sure that all of this works in real time. So give me just a moment. Let me get my bearings so
Yeah,
I can make
take your
sure I
time.
find this. because
I'm
this
so
is good
grateful.
information.
Absolutely. I'm so grateful for the information that you are bringing and you are contextualizing it theologically, because the work that we're doing intersections of faith and abolition, with the focus on Black women and Black motherhood and their communities. So it's really important that we see how our faith could create counter spaces to oppressive systems, including the legal system. Were you able to bring your slides
I
up?
am getting there. Of
Okay, take your
course, the
time.
technology is doing what it's doing. So I'm going to try and see if this is going to pop up the way it's going to pop up. Can you all see that?
It
It
says
says
it's opening.
opening.
Yep.
Can you see this?
Uh, so let me yes, we can. That's
You can
perfect.
see that.
Yes.
Okay.
Well, one moment. It's
Uh-huh.
loaded. Yep, we're good. We're good. We're good to
Okay,
go.
we're good.
Thank you so much.
All right, thank you. So I'm just going to try and flip through here as best I can, because this is going to be a little disjunctive. Okay, so this is where we were. We were talking about the logo and the ethic of LegalEaze, please. If you look to the left of your screen, you will have the name of our company, LegalEaze, please, where we decode, deconstruct, and demystify legal language. Okay, so now we're going to go to the next slide that talked about the partnership between Abolition Sanctuary and LegalEaze, please. Then we talk about the tenets of abolition sanctuary, compassion, care, creativity, courage, and we do it in community. Okay, so this is where I am. Okay, hopefully everybody can see that. All right, so in the book of Jeremiah, which is a study, if you will, of Dr. Jeremiah Wright, his life, his ministry. It is written by Dr. Susan Williams Smith. Dr. Wright is quoting, or he is summarizing the premise of Dr. Jones' book, God in the Ghetto. And the framework is as follows: how I see God, how you see God, then determines how we see each other, which then determines in what hierarchy we put that person or those persons. So if as I was, my example was, if I see God as male, cisgender, heterosexual, capitalistic, and I worship, I revere that deity, then what happens is that everyone who is not a reflection of what I revere or to what I give allegiance, then those persons are not revered by me. So if I, Natasha, am a cisgender, heterosexual Black woman, Black mother, but that bumps up against a white God, then what happens is the believer, the worshiper, the person who holds the allegiance to the white God is not going to hold allegiance to me. Okay? So what ends up happening is that when you have these beliefs about who God is and who God is not, based upon what I believe God to be, then I take that belief and I now insert it into different other areas of my life, such as legal, such as financial, such as economic, such as religion and theology. So if when I say God, my God is different than your God, then I have no problem being able to worship in a church and then go outside of the church, because the church is located in a slave castle, and then engage in human trafficking of African bodies. There is no difficulty with that, because I believe my God is white and my God is awesome and my God is very patriarchal. So that anything that is the opposite or the antithesis of that, I have no problem treating that subject like an object, because I don't see the divinity in them. Now, I hear someone saying, I don't even mess with Jesus like that. I don't go to church like that. So this is already a conversation which I can leave. Before you go, understand that I also expand the definition of God to be more than just a deity. God can be a school of thought. God can be a pedagogy. God can be a collection of beliefs or ideas or scholarship. Anything that a person holds dear or reveres or it is allegiance to, that is their God for the purposes of this conversation. The reason why this is important is because when we look at our laws, when we look at different policies, when we look at different procedures, the reason why there are certain persons who are attacked because the law does not give equal protection. The reason why that is in place is because those laws were never intended to take care of or revere people outside of someone's preferred ethic or ethos. Okay, I hope I'm making sense. So, for example, let's just go outside of the church and let's just talk about classrooms. When I am teaching professors, I tell them all the time, I can tell what you revere based upon what you put in your syllabus. I can tell immediately. So if you are teaching any subject and it has a lot of white, dead men in the syllabus, but you are teaching transgender, you're teaching non-binary, queer, women, non-English speakers, persons who do not speak English as their first language, those who have immigrated to this country. If you are not reflective of who you teach, I already know what you revere. Okay, so this is important because when we have this conversation about the criminal legal system, you are going to see that there are certain structures that are put in place based upon what the builders revered. Okay, you want to take a look at it? Look at the Constitution. Look at how blacks were defined. They were defined based upon not their humanity or their divinity, but because of how they were considered to be taxable. So that is why for every enslaved African or black, they were considered to be 3/5 of a white person. That is in the Constitution of the United States. If you look at the 13th, the 14th, and 15th Amendments of the Constitution, the 13th Amendment is eradicating slavery. The 14th Amendment is making enslaved blacks. When I say enslaved blacks who are now free, I'm talking about black men. I'm not talking about black women yet because we don't get addressed until the 19th Amendment. Okay, so the 13th Amendment is eradicating slavery. The 14th Amendment is making enslaved blacks men, citizens, and then the 15th Amendment is giving free black men the right to vote. Now, the right to vote and the actuality of voting are two totally different things, which is why you had the Voting Rights Act of 1964. Okay, so I say all that to say is that when you have embedded in the law of the land the fact that you're already coming into the situation as a fractured person, not because of who you are, but because of what the law tells you. And then the law gives certain amendments or certain changes to that law. But just because it's a law in right does not mean it's a law in actuality and procedure. So that is why you still have this struggle for those who are anybody other than white, while there is this struggle to get recognition. This is why in the year of 2023 in the state of Georgia, you have persons who are going to be arrested and charged with a crime if they try to give food and assistance or water to those who are standing in line to vote. This is why you have in the year 2023 in the great state of Florida this buzzword called critical race theory, which says, how dare you try and teach about the truth of this country? So if you even try to teach anything other than, land of the free, home of the brave, you could lose your rights. You could lose your job. Okay. This is why you have in Tennessee now, the Tennessee two who were being extracted from legal places where they were supposed to be because they were elected to be there. Okay. This seems like this is a lot. And you're like, what does this have to do with the criminal legal system? I'm finna tell you what it has to do. Okay. So when we're talking about morality and legality, my argument is that you will see the legality of something always following the morality of something. So remember, I am partnering with Abolitionist Sanctuary, which is focusing on Black women and Black mothers specifically. I submit by the reason why moral and legal language and laws for us, Black women, and Black mothers are so oppressive is because of the following. The existence of our laws of our society always follows the ever changing morality of our society. Ever changing, because just when you think your moral behavior is falling within the boundaries, then the boundaries shift. Think about how there was a time where the consumption of alcohol was illegal. It was illegal because morally, the persons who were in perceived power felt that alcohol and the consumption of it really need to be relegated to persons of color. And then when they saw that there was a business or a profit share to it, all of a sudden they decided, you know what? Let's make alcohol legal. So then the morality around alcohol consumption changed into what? The codification that you can drink and consume alcohol without punishment. Let's think about the use of marijuana and how morality indicated that your body was a temple and that you were not supposed to consume anything that was from the earth, anything that was plant based, until there were people in perceived power who believed that there was money that could be made on the backs of Black and brown lives. So all of a sudden, the laws started changing because the morality of people changed. Okay. So every time you want to see where a law is going, you trace where the morals are. And the problem is that for Black women, for Black mothers, there will never be able to be a morality line because the line keeps changing. Okay. I also submit that the reason why legal language and laws are so oppressive is because who we say God is and who God really is differs based upon what I set as a framework that God is not just a deity for some, but for others, it is what they are allegiant to, what they revere. It could be systems, it could be laws, it could be beliefs. Lastly, how we see Black women is a truth telling reality of how we don't see God as Black women or in Black women, and how Black women are not made in the image of God. Now, I know I'm stepping on some toes, but you know what? I got time. That's what I'm here for, is for us not to just evade this, for us not to just weaponize language and laws so that we are marginalizing those whose narratives, whose lives need to be centered, but that we acknowledge these things, that we have conversations about these things, that we don't just sweep it under the proverbial rug. Okay? These are some of the reasons I argue as to why laws tend to oppress those like us, is because you have lawmakers who are very religious, very theological in their beliefs, and they don't think that the objectification of people is incongruent with what they believe. Okay? Because the God that they serve is the God of the oppressor as opposed to the God of the oppressed. Okay? So that is the framework from which I am teaching. I'm going to move on. So now that you have that, I want to raise this quote from Audre Lorde, who is a prolific poet, revolutionary, And one of the things that she held fast to was this notion that there is no such thing as a single issue struggle because we do not live single issue lives. Okay. So even though you may have signed up or you're watching to learn about the law, you will see that there is not only the intersection of law and theology, of law and biology, of law and finances, that there is also integration. And so, if we are to use the term intersectionality, which is a term that was coined by Dr. Kimberly Crenshaw, who is a law professor in California, then you are to say that every time we have a conversation, every time we move into a space, we are not just a Black, or we are not just a woman, or we are not just an English speaker, or we are not just queer, or we are not just non binary. We are the totality of who we are. And we are not going to enter into these systems of oppression that would have us relegate any part of our identity to the side. We come in as whole people, we come in as integrated people. And so these are the things that we bring to these systems to understand them better. All right. Now, an outline of our series. As I said, part one tonight is about the arrest, the bail, and the bond. Part two, we're going to the criminal court case. What does that look like? What does it mean when you have a prosecutor and a defense? And what do they have to prove? What do you have to prove? And in part three, we're going to be talking about the trial. And then I'm going to conclude with building legal sanctuaries by using what I call everyday activism. Okay. You still with me? I hope you're still with me, because now we're going to go into part one. Part one is the arrest, the bail, and the bond. Okay. All of what we are talking about as it relates to being arrested comes from the Fourth Amendment of the United States Constitution. Yes, the same Constitution that said that for those who were Black persons, especially those who were enslaved, that you were considered to only be 60% of a person based upon taxation without representation, how you would be counted by the law. Well, if you move a little bit up and you'll see the Fourth Amendment, which was written, I believe, in like 1787, 88, 89, it says, and I quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation, and particularly described in the place to be searched and the persons or things to be seized. All right, I hear you saying, Professor Robinson, don't nobody talk like that anymore. And you know what? You're right. Okay, unless they are in some type of theater or period piece. But this is the part of the Constitution that covers hundreds of years of cases and procedures and policies that would have us learn about what does it mean to be arrested, what are the conditions for which law enforcement can arrest someone, and what could we do if we feel we have been mistreated by the police. Now, there are some terms that I want you to familiarize yourself with. Okay? Search, seizure, warrant, probable cause. If and I'm taking this language out of the Fourth Amendment, where it says the right of the person is to be secure against unreasonable searches and seizures. So the Constitution does not say that you can never be searched and you can never be seized, that you can never be searched, or your house, your car can never be searched, and illegal items can never be seized, which seizing is nothing more than taking. Okay. What it says is that we are United States citizens are free from unreasonable searches and seizures. So searches and seizures are not illegal on its face. It has to be unreasonable. Okay. And when we use search, we're talking about law enforcement or anyone acting as an agent of law enforcement. A search is nothing more than looking for illegal stuff. Okay. Anything that you do not have a right to have legally, that is what law enforcement is looking for. A seizure is when law enforcement finds that illegal contraband and they take it into evidence. Also, a seizure is another term for an arrest. So when a person is arrested, another term is they're being seized. Okay, they're being taken into custody. Now, we don't call it a seizure, but I want you to know anytime you see in search and seizure law that a seizure is not just the taking of tangible things, it is also the taking into custody of people or of persons. All right. So, out of the Fourth Amendment, if a person is to be arrested, law enforcement, according to the Fourth Amendment, written in the 1780 something, law enforcement has to have one or two things, either a warrant or probable cause. A warrant or probable cause. Okay. I want you to know that and focus upon that. So, from the Constitution, which says that you have to have a warrant or probable cause, we go to court cases. So now we are talking about searches with warrants, searches without warrants, which are called warrantless searches, and probable cause. Because remember, the Fourth Amendment says to be protected from unreasonable searches, what we're looking for, and seizures, what we're taking, law enforcement has to either have a warrant or probable cause. Okay, so we're going to talk about searches with warrants. In warrants, every warrant has to have two things: the thing that is to be taken and the location that you believe you're going to find it. Okay, what you think you're going to take, which if you were in law enforcement, you don't always know what you're going to find. And so sometimes you will have to go in front of a tribunal, which is another word for a judge, and you have to fill out an affidavit. And in that affidavit, you say, "My name is Natasha Robinson. I am a detective of this particular agency. And upon my surveillance, upon an informant, based upon my investigation, I believe we are going to find these things. And we're going to find these things at this address." So what happens is that the judge will swear the police officer under oath. The police officer will write that information in that affidavit, and then that officer is sworn to that affidavit. The judge will determine whether or not that affidavit is solid, and then the officers will execute that warrant. They will carry out a warrant. Now, just because you have information in the warrant does not mean that that information is true. I want you to go back in time to March 13th, 2020. On that day, March 13th, 2020, you had officers from Kentucky that were engaged in a search warrant. And the search warrant was looking for a particular person who was accused of selling drugs out of their home. Well, these officers used this search warrant as, I would argue, a cover up for doing a very wide investigation. They were throwing a large net, and what they end up catching was not only a person who may or may not have anything to do with what the search warrant was about, but they also went to the home of Breonna Taylor. Breonna Taylor was an EMT out of Louisville. The officers, when they bust into her home where her fiance was, they ended up killing her while she was asleep. And they ultimately charged her boyfriend with trying to engage in the attempted murder of an officer. Well, it was only after a lot of investigation that they realized, and when I say they, law enforcement outside of the ones who executed the warrant, that the information in the warrant was faulty in the first place. That they were just using it as a weapon to try and search for whoever this person was. Now, the searching for the person, if that's what you want to do as law enforcement, because you do want to make sure that neighborhoods are safe and that people are not victimized, then by all means go for it. But you cannot Cannot. You cannot break the law in order to catch someone by the law. And that is what these officers were doing, which, by the way, as of March 13th, 2020, there still has been no arrest for the murder of Breonna Taylor. There has been an arrest in terms of the people living in her apartment building, but there has been no one who has been charged with any crime related to her murder. This is what I'm talking about when we're talking about the protection of Black women. They, the officers, did not believe in engaging in care and concern. They were on, it was not knock and announce, but shock and awe, just jumping in. And you will hear, if you Google the testimony, how you hear that there were people who were shot, or rather their apartments were shot in this apartment complex because the officers was like, by any means necessary. So when you have searches with warrants, which is what the Fourth Amendment allows, it is saying that in that warrant, you have to be careful about describing the place to be searched and the persons or the items to be seized, to be taken. Criminal courts recognize, as well as law enforcement, that sometimes you don't have the time to be able to get a warrant because there may be what's called exigent circumstances, emergencies, where you have to stop a suspect in their tracks. So think of if there is a kidnapping or something. And so the law enforcement doesn't have time to always go and engage in a search warrant if they're trying to trap the kidnapper. If the kidnapper is going on hot pursuit, the law enforcement, it doesn't make any sense for them to say, hold on a minute, I know we are engaged in a high-speed chase. Let me go over to the courthouse and get this warrant so that when we stop you, we're able to arrest you. The criminal courts recognize that there are some situations which merit there being no need for a warrant. Those are called warrantless searches. And those are examples of when law enforcement thinks that a suspect is going to destroy a particular piece of evidence. If they're in hot pursuit, which means they're chasing a suspect and a suspect busts into somebody's home, the police do not have to stop their chase and then go to the courthouse and get a warrant. They can continue in the hot pursuit. If there is a search, which is where there is a contraband that is left out in the open, that is a warrantless search in the sense of there is no expectation of privacy. If you leave things out in the open, the law says that you have no expectation of privacy if the law enforcement officer is already there and sees those things. Okay, so to backtrack, the Fourth Amendment says that, one, as United States citizens, we are free from unreasonable searches and seizures. If there is to be a search and a seizure, law enforcement is either needing to have a warrant, or if they don't have a warrant, they need to have probable cause. Now, probable cause means a lot of things to a lot of people. If you ever serve on a jury, most juries do not have an instruction for what probable cause is. It's kind of like when someone is visibly pregnant. You know it when you see it. Okay? Now, the United States Supreme Court has given some language and some instruction on how to determine if there is probable cause. So I teach this by way of 3 steps to an arrest. 3 steps to an arrest. The first thing is that law enforcement officers, when they decide whether or not they're going to arrest someone outside from a direct tip or a direct observation of violating the laws, the officers have to have what is called reasonable, articulable suspicion. What that means is they have to be able to articulate to a judge, I believe that this person was committing a crime, was about to commit a crime, or had just finished committing a crime. And they are giving factual basis. I saw this person pacing back and forth, and they had burglary tools on them. Then when I saw them take the tools out of the bag and then go to a part of the house that was dark. or when I saw this person wearing a mask over their head and they didn't enter in the front door, but they went around the back. All of those are reasons why you are able to articulate suspicion that the law is about to be broken. Okay. And that language comes from the United States Supreme Court case of Terry v. Ohio in 1968. Then what ended up happening is that once an officer is able, the first step to articulate that they believe something is illegal is going to happen, then the probable cause is it more likely than not that they are actually committing a crime, about to commit a crime, or has committed a crime, which is why it's difficult to pinpoint what probable cause means because it varies in jurisdiction and it varies among law enforcement officers. Okay. But what I do know is that if you are suspected of something, but the police step over your constitutional rights to arrest you, then that is called fruit of the poisonous tree, which means if you have a tree that is growing and it is poisonous in its root, then whatever the tree produces is also poisonous. So if you have an arrest where a person was stopped only because they did not fit the demographic of a particular neighborhood, and the officers pat down that suspect and find some cocaine, even though the cocaine is illegal, the stop or the arrest is also illegal because there was no observation of that suspect doing anything illegal. He was just walking down the street in the wrong neighborhood per the law enforcement, and that's why that person is pulled over or stopped and patted down, also known as a Terry pat down or stop and frisk. And a lot of the cases that I had in criminal court involved people that fell under a range of 18 to 30, had on a white t-shirt, some dreadlocks, and they were walking through particular neighborhoods. They would stop these persons, pat them down, and find weed or cocaine, and they were charged with different crimes. And then I would come in as their attorney and said, even though these items may be considered to be illegal, you cannot be illegal by jumping over their constitutional rights in order to make your case. Okay? So, 3 steps to an arrest. First, reasonable suspicion. Can the law enforcement officer articulate the reasons why a suspect was stopped or questioned or pat down or detained? Secondly, there has to be probable cause for the arrest. Is it more likely than not that a person is committing a crime, has committed a crime, or about to commit a crime? That's a second level. So then the third step is the actual arrest, where the person is seized or they're placed into custody, and then they are taken to the station in order to determine what their bail or their bond is. All right. What I forgot to tell you is that there is no way I can tell you in less than 60 minutes all of the information that you need to know about the Fourth Amendment. What I'm trying to do is I'm trying to take different pieces and I'm trying to coalesce them so that you have a general understanding, a layperson's understanding. And then if you want to engage in a deeper understanding, you can do your own research. You could take several classes. You could talk to different attorneys. You can do all of the things. Okay. So once we go from the arrest to the bail or bond hearing, we are talking about what is the conditions under which a person can remain in custody or be released with the hopes of them continuing to come to court. Now, there is no universal description about what bail or bond is, because right now bail and bond is interchangeable depending upon what state you live in. For the state here I'm in, Illinois, we use the term bond. And prior to January 1st, 2023, there were 3 types of bonds. You had an I bond, which means you released on your own recognizance, your own identity, or your signature. That was bond number one. Bond number two was called a D bond, which means you had to, if you were in custody, you or your loved one or your friend had to present 10% of what that bond was in order for that person to be released. So if that person got $100,000 D bond, 10% of that had to be $10,000. That is, if that person was not put on house arrest or electronic monitoring, or someone did not sign over their home in order to secure or guarantee that person coming to court. Okay. And then the last type of bond that we had in Illinois was called the no bond, which means that because the allegations of the crime were so severe, and because that suspect could be a threat to the community, there was no bond, meaning there was no way that that person even had an opportunity to post a percentage of their bond. So once you are arrested, depending upon if you are charged with a misdemeanor, which is a less serious offense, or a felony, which is a more serious offense, the very next step usually is the bond hearing. If you are not able to get a bond at your station because, let's say if it's speeding or traffic or something like that, most jurisdictions will allow you to bond out at the police station. But let's say you don't have that opportunity. When you go to court, there are things that the judge is to consider. The judge is to consider factors of aggravation, which is what are all of the big reasons why you should remain in custody. And the judge is also to consider factors in mitigation, which are what are all of the reasons why you shouldn't be in custody. So factors in aggravation include if there was a weapon, the age of the alleged victim, the neighborhood, if a person has prior convictions, if they have a pending case, which is while they are fighting case number one, they may pick up case number two. If the person lives with a disability, if they are a veteran, if they are a senior citizen, if they are a police officer, if they are EMT, all of these things are considered in aggravation. The severity of the injury, if this is something that the victim is able to get treated, or if there's something that severely disables them or kills them. All of these are factors of aggravation. Factors of mitigation are who is a suspect. If the suspect in school, what is the age of the person? Are they a spouse? Are they a parent? Are they a caretaker? How far did they go in school? Are they a veteran themselves? Do they live with any mental illness? Do they have any physical challenges? Do they speak any other languages other than English? Do they need assistance by way of modifications? Like, do they need a language interpreter, translator? Do they need American Sign Language or a relay translator? All of these are factors of mitigation. Do they have a job? How far did they go in school? Are they the main breadwinner of their family? And then what happens is that the judge considers the charge, the alleged facts, and then the factors of aggravation and factors of mitigation. And with all of that information and the law, the judge makes a decision. And that decision is whether this person should remain in custody for the duration of their case, or if they have the opportunity to bond out because they are not a threat, they've never missed court, this is a non-violent offense. All of these are things that we need to consider. And so with that, that is my time. Okay. So what you see on the screen are the ways to stay in touch. If you have any questions which you want to email me, you can email me at legaleazeplease@gmail.com. You can go to the websites of www.legaleazeplease.com, or you can look for me on Linktree, and you will see not only who I am, but the podcasts I've been on, the blogs that I've written, all the things. And then tomorrow, when we come back, we are going to be talking about criminal court, meaning once we get through the bond hearing and the bail hearing, what happens then? Why are all these people talking all over us and we have no idea what they mean or what they're saying? Remember, we want to break down every barrier that includes knowledge, access, and comprehension. So hopefully you will meet us tomorrow for part two. And that is my time. Thank you so much.
Thank you so much, Professor Robinson. Look at you. I'm claiming kindred spirits. Thank you so much, Professor Robinson. You gave us a semester's worth of content in less than 60 minutes, and we are so grateful. I'm receiving messages from people saying how useful this information is and how awesome this platform is, and that we are innovating new pathways that gives our community accessibility to information that we so desperately need in order to advocate for ourselves and
Mm,
to survive, right? And so, thank you so much for this wealth of legal information as we think the legal system, but also dismantling it, right?
yeah, yeah.
In ways that we can thrive in more just and equitable systems. So, thank you all for joining us for the first day of Abolitionist Academy 101, which is installment of our Abolition April that is presented by Abolitionist Sanctuary. We're bringing you 30 days of abolition that celebrates the past and present struggles with freedom and ways in which it points to abolitionist futures. Will see you again tomorrow, same time, same place. Please share this live or recording and follow us on YouTube. You can subscribe to our channel at you can also find us at Abolition Sanctuary on Instagram and Facebook and Twitter. We would love to see you and your community here tomorrow. Thank you so much, and we wish you a good night. Thank you,
Good
Professor
night.
Robinson.